The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Welcome and thank you for attending the Office of Respiratory Therapy Licensure Stakeholder meeting via webinar today. Before we get started, I wanted to make some introductions. I'm Karen McGovern, the Deputy Division Director for the Division of Professions and Occupations. With me on the line to help facilitate the meeting and to provide subject matter expertise are Laura Bravo, who is a policy analyst with the division, Ophelia Duran, who is the program director for the Office of Respiratory Therapy Licensure, and Zen Mayhew, who is the program director for the Director Model Unit. In compliance with the governor's orders regarding the COVID-19 pandemic, the division has transitioned to a platform that is 100% virtual. We appreciate your flexibility as we work through this process and get used to what people refer to as our new normal. Because the stakeholder meeting is virtual, we'll talk a little bit about how you can participate. If you want to speak, ask questions, or otherwise join in the conversation, you just need to click on the raise hand icon. And once you raise your hand, we will unmute your line and call on you. If you don't want to provide speaking feedback, you can always put your comments or questions in the questions box, and that will we'll get those questions, and then we will read them back to the group and either answer the questions or just make sure that everybody has the benefit of hearing your feedback. Your comments today are very important. We make decisions every day that may affect your life and your business. And so your input into the rulemaking process is vital. Through the rulemaking process, our goal is to create rules that clarify and explain legislation, that ensure the minimum competency to enter and continue the practice of respiratory therapy, and to provide only that regulation that's absolutely necessary for consumer protection without creating hurdles or unnecessary barriers or burdens for those that wish to enter the marketplace. Today we're going to talk about Colorado House Bill 1326, which creates an Occupational Credential Portability Program. It's also referred to as the Red Tape Reduction Act. That law will affect the way that we process endorsement applications. And endorsement applications are those people who hold a respiratory therapy license in another state and want to come into Colorado. And so we'll talk about that as we get going through the rules. That law also allows for military spouses to obtain a temporary license to practice respiratory therapy if they are licensed in another state. That temporary license is free of charge and allows them to practice in Colorado for 3 years while their spouse is stationed here as part of their military orders. The other bill that we want to talk about is Colorado Senate Bill 20-102. That bill requires providers, healthcare providers, to disclose any professional license discipline or convictions, criminal convictions, or pleas of guilty to sexual offenses. So what that means is that if you hold a professional license, your respiratory therapy license, and your license is disciplined for sexual misconduct, you'll need to disclose that to your patients before you treat them. The other piece of that is if you are convicted of a sexual offense and you're serving a term of probation or parole or any other sentence of the court, you will also have to disclose that to your patients before you provide treatment. I recognize that respiratory therapy does a lot of work in inpatient settings, and there is an exception for that. And we can talk about that when we get to that rule. The other purpose of looking at the rules today is we're doing the mandatory rule review that is required by law. The Administrative Procedure Act requires that an agency review its rules every 5 years to make sure that we are looking at each rule to make sure that it's still necessary, making sure that it's not overly burdensome, and that we're capturing what we need to in the regulations to effectively protect consumers. So just making sure as we move forward, if you have a comment when we unmute your line, making sure that you're minimizing any background noise while you're speaking. We do get quite a bit of feedback on this platform, and so we want to make sure that everyone has the opportunity to hear what you have to say. And also, if you're using the audio through your computer, please make sure to mute or turn off your phones again so that we're not getting that extra noise. So I think we can get started with the rules. Making sure that if you're going to provide a comment that you state your name and you state who you represent. That's important for the record. And we have a small group today, so I'm not going to limit the time of comment, but just making sure that everybody's mindful that we want to create a space where everybody has the opportunity to provide feedback. With that, we will get started. Does anyone have any questions before we start looking at the rules? Okay, I don't see any questions or any hands raised. So when we look at Rule 1.1, there you can notice that the changes are in red. We call it red line. And I'm hoping that it shows up on your screen as red, but basically any of the words that are in colored type means that that's a change to the rule. 1.1 and 1.2, those revisions were made to make sure that the rules are consistent with the Secretary of State formatting guidelines, and there's no substantive change to those two rules. When we look at Rule 1.3, oxygen deliveries, this is a rule that I really wanted to get some stakeholder comment on. And this is a rule that we get a lot of questions about from people in the community. And it has to do with what respiratory therapy services can be rendered by an unlicensed person who delivers oxygen supplies. And so the current rules say that they can deliver, set up, inspect, and maintain an oxygen apparatus, that they are allowed to instruct the patient about how to operate the apparatus. And then the second piece of the rule says that the unlicensed delivery person may not perform pulse oximetry testing, interpret or report physician orders. They may not titrate the oxygen level. They can't discuss disease status with the patient or engage in any other task or duty that constitutes the practice of respiratory therapy. So that is what the rule currently says, and I'm wondering if anybody on the call has any feedback or any comment about this rule.
Thanks, Karen. And again, for those on the call, you can raise your hand if you'd like to speak. I do see a written comment. Let me make that a little easier to read. Kimberly Hegeman says, agree with it the way it is stated.
Okay. Thank you.
Thank you.
Okay. For declaratory orders, this rule talks about how the director will handle any request from the community asking for a declaratory order. We don't really get a lot of questions on this rule. Questioning whether the rule is necessary. I do think that it's helpful for licensees to understand how they can ask for an opinion from the director. I am going to move through this rule, and if someone has an objection to it, I'd ask that you raise your hand or that you put a question in the question box. The next rule that I want to talk about is the requirement for reinstatement. So the purpose of this rule is to make sure that we have procedures in place for those respiratory therapists who allow their license to expire. And basically what the statute says now is the rule says now is if the license has been expired for more than 2 years, but less than 5 years, then there's a list of things that person would have to show to the director so that they can establish that they've maintained their competency as a respiratory therapist. And so the things that we require are that either you have a license in another state or that you have otherwise maintained competency by completing 30 hours of continuing education courses related to the practice of respiratory therapy during the 2 years immediately preceding the application, or documentation that demonstrates that the licensee retook and achieved a passing score on the national examination within the 2 years preceding the application, or by any other means approved by the director. So I think this is a point where, if you have any feedback, or there are other ways that someone can demonstrate that they've maintained their competency as a respiratory therapist, that you would like the director to consider. Do you think that 30 hours of continuing education is a good amount, or do you think it should be less or more? Now would be the time to provide that feedback. While I let you sort of think about that, for people who allowed their license to lapse for more than 5 years, would either need to show a verification of a license in another state, that they had supervised practice for a period of no less than 6 months, subject to the terms established by the director, or that they retook and passed the national exam. So if you let your license expire for more than 5 years, you can't just take the CE to demonstrate your competency. You're going to have supervised practice or retake an exam. And so wondering if there's any feedback about that.
I have a comment from Kimberly Hageman. I'm not sure in regards to which specific section, but she does think it sounds good.
Okay.
And Kimberly, if you want to explain further, that's fine. Otherwise, we'll note that.
The next rule talks about reporting convictions and other adverse actions. It looks like previously the rule said that the licensee had 90 days to notify the director if they had a conviction to a felony or under the laws of any state or the United States. We have changed that time to 30. 30 days is consistent with the other professions, and also when you think about protecting the public, 90 days is a long time to find out that someone has been convicted of a sexual offense or an offense that has caused serious bodily injury to another person. Does anybody have any feedback on that?
In regards to the section regarding renewals when expired, Robert Scott says he agrees with the renewal when expired rules.
Okay. Okay, so move down. The next rule talks about duty to report information to the director's office. This talks about the licensee's duty to make sure that the director has contact information for licensees. I think this is really important when you talk about regulating a professional. The person who is the regulator needs to have a way to contact that professional. And I think what we will see a lot is we will get a complaint, and when we try to reach out to the licensee, we can't find them. And that creates a whole host of problems, because if the director can't find the licensee, then the licensee doesn't have an opportunity to provide their side or their response to the complaint. So I do think this is an important piece, but I'm interested if anybody on the line has any feedback about that.
I have a couple comments in written form that I'll read. Robert Scott says agree with change to 30 days. And Kimberly Hageman says the same, agree with the 30 days.
Okay, great. You have a rule that is very progressive, allowing credit for military experience toward the training and education piece. And so I wouldn't recommend any changes to this rule. I think that this is very much goes in line with the spirit of making it easier rather than harder for people to obtain licensure after they have received training. The change that was made to 1.7 was just removing the statutory citation. This rule talks about how a licensee would report a medical or physical condition that impacts their ability to practice. This talks about the process to report that to the director so that the licensee could be eligible for a confidential agreement. Confidential agreements are a mechanism where if, as a licensee, you had a condition such as Parkinson's or multiple sclerosis, or if you had neuropathy, after you had a round of several rounds of chemotherapy, if you were recovering from a stroke, that you could enter into a confidential agreement with the director to ensure that you continued to be safe to practice. And so if anybody has any comments about that or any suggested changes.
We had a comment from Kimberly Hageman, I believe, regarding the military credit, saying that she agrees.
Okay. The next rule is a pretty recent rule that was added, and it talks about the new law that requires that healthcare providers provide a disclosure to patients if they are an out-of-network provider. And so essentially, this rule came into play to say if you're providing services to a patient and their insurance is not going to cover your service, you need to let the patient know that. So if anybody has feedback on this one, I think this one was just adopted within the last year. Okay, and then the last rule that you have is the new rule that we're proposing be put in place that goes along with the Senate Bill 20-102, which is the required disclosure to patients about a conviction or discipline based on sexual misconduct. So you can see the new law requires that the director make rules about this. And through these rules, the director is pointing out that this new required disclosure starts on or after March 1st, 2021. So basically, starting on March 1st, any licensee or registrant that has either the conviction for which they're on probation or the license discipline for a sexual event, a sexual misconduct, sexual offense, they have to make a written disclosure to the patient before they provide services. The form of disclosure talks about, first, that it has to be in writing, that the patient has to sign the disclosure form acknowledging that they received it, but also agreeing to treatment. And essentially, if you think about it, it goes back to the intent of the bill, which is that patients should, if their healthcare provider does have a conviction for a sexual assault, then as a patient, they should know about it and have the right to see another provider. You'll see that paragraph B talks about a sample model disclosure form, and we have included that in the appendix to the rules. And what that does is it gives guidelines and tells the licensee who has to make the disclosure exactly what they have to have in that form. And so as you look through it, it's pretty extensive. It requires that you list any final convictions or guilty pleas for a sex offense. And then there's all these things that you have to disclose about the guilty plea or conviction. The date of the conviction, the nature of the offense, what the sentence looks like. So are you on probation? Did you go to prison? And now you're out on parole. All of those things have to be included. There's a similar requirement if your professional license or your license to practice respiratory therapy was disciplined for either that conviction or if it was disciplined for another instance of sexual misconduct. And so needing to make sure that you include all of that information in the disclosure, and it goes through the same thing. You need to be able to tell them if your license was disciplined, you need to tell them who disciplined it, whether you went to hearing or whether you entered a settlement. If you were placed on probation, what does that probation look like? And interestingly, in here, you'll have to provide the contact information for the board or the regulatory agency that put your license on probation. The other really important piece of the model disclosure form is making sure that the signature block is inclusive. So it's important that the client's name is on the disclosure form printed and that the client or their guardian has signed it. It's important that the licensee sign the disclosure and that dates are put on here. I think that it's important to note this would have to be part of the patient's medical record so that you could then ensure that this disclosure was provided if that was ever called into question. If you are required to make this disclosure and it's not made, you can face additional discipline against your license. And a couple of important pieces are that if you have a patient that you see regularly, that they continue to come back and you continue to see them, you only have to make the disclosure once unless the information changes within the disclosure. So if your probation was extended, then you would have to give them a new disclosure telling them that you are on probation for another 6 months. So that's an important piece. The other piece that's really important is that if you were convicted of a sexual assault and you were put on probation, as soon as you complete your probation, as soon as you are successfully done with your sentence with the court, then you no longer have to make the disclosure. And that is exactly the same if your license is disciplined, as soon as you complete your requirements and your license is placed back into a status of active without condition, then you no longer have to report the sexual offense. And then the last piece that's really important to note is all of the exceptions. So if the patient is unconscious or they're otherwise unable to comprehend the disclosure, and that would refer to, if they had a cognitive issue and they weren't able to understand, and their guardian is not available, then you would not have to make the disclosure. If the patient visit occurs in an emergency room, a freestanding emergency department, or in an inpatient facility, you're not required to make the disclosure. If the licensee providing the service to the patient is not known to the patient until immediately prior to the start of the visit or to the start of providing services, you don't have to make the disclosure. So how that would translate in respiratory therapy is if you get called in to treat a patient and the patient is already crashing, you're not required to make a disclosure before you're able to provide treatment. And then the last one is for a licensee that doesn't have a direct treatment relationship or have direct contact with the patient. And that exception was really put in place for instances like a pharmacist who might be in a completely different building, filling a prescription, putting the pills into a bottle, and might never see or have any contact with the patient who is going to eventually get that bottle of medication. This is not intended to be an exception if you are providing services through telehealth. So that is a lot to digest. And so I want to take some time to see if anybody has any questions or comments about this new rule.
Karen, I don't see any questions about this rule. There were a couple comments regarding the insurance piece.
Okay.
I don't know if we can go back to that. I had a comment from Kimberly Hageman.
Okay.
And her comment was, we do not know about insurance in providing care to patients in the hospitals.
Mm-hmm.
And then Robert Scott said, agree with disclosure if cannot accept insurance, etc.
Right.
And Kimberly or Robert, if you'd like to clarify those comments at all, feel free to raise your hand. Otherwise, those are noted for the director to review as part of this rule making.
I do think if you raise your hand, we can certainly address any of your concerns, but I'll try to address them as written. I think that if you are a respiratory therapist and you're working for an inpatient facility or a skilled nursing facility, and it's important for you to know that they are also required to make those disclosures to the patient. So obviously, if you're working as a respiratory therapist in a hospital, you don't even know what insurance the patient has, or if the hospital is a out-of-network provider for the patient. And so I think that for staff that is employed by a hospital, I think that this is not a huge concern for that staff. Where it becomes a concern is if you're working as part of if you're a contractor. So if you work for an agency and you go into a hospital, that's something that you would have to talk to your agency about and make sure that those disclosures were made by the person that you're working for.
Okay, thank you. I don't see any other comments or hands raised. Another comment just came in. Robert Scott said, in an OP setting, Kimberly is right about inpatient setting.
Mm-hmm.
And then Kimberly said thank you. So I guess your explanation helped. Thank you.
So at this point, we've covered all the proposed rules, but certainly if there are other rules that you want to talk about, or if there's other rules that you think we should have, if you have any questions about anything we talked about today, now would be the time to provide that feedback. While you think about if you have any further questions or concerns, I'm going to switch my screen off so that I can get the dates for next steps. Okay, so the rulemaking hearing, so that will be when we have the formal hearing to adopt these rules for the director to consider them, will take place on September 30th at 12 o'clock noon. We will file these rules with the Secretary of State on Monday and make sure that we, to make sure that those are properly noticed in accordance with law. We will send a notice out to all the respiratory therapy licensees and also anyone who is on the stakeholder list as someone who's interested in information about rulemaking. And on that notice, it will have the date, which again is September 30th, and the time, 12 noon. And it will also have a link, just like the one today, so that anyone who's interested can participate via webinar. If you walk away and you think of other things that you wanted to bring up, you can certainly provide written feedback to us and send that to Dora, D-O-R-A _ DPO _ rulemaking at state.co.us, or you can submit written comments in writing. You can send those to the Office of Respiratory Therapy Licensure at 1560 Broadway, Suite 1350, Denver, Colorado, 80202. I don't see that we have any hands raised or any further comment. So I wanted to thank you for your participation and wish everyone a good weekend. Thank you.